Good morning. We are here with Alfredo Gorni, a lawyer and professor in charge of our module Introduction to the Fundamentals of Civil Law, in order for him to tell us something about the contents of this unit.
Okay, the content of the unit deals with the fundamentals of contract law in a civil law country like Italy, which is taken as a sort of model legal system, just to explore the main topics of the contract law. We have the opportunity to go through the essential elements of the contract, which are important for the contract formation. Then we analyze the main situations affecting the effectiveness of the contract, such as the presence of condition precedent and condition subsequent. And more in detail, we go through the interpretation of the contract provisions. In addition, we explore all the situations relating to the so-called precontractual liability, which is the liability that the parties to a negotiation may incur in situations in which at a certain point, after a lengthy negotiation, they decide to withdraw from the negotiation without a real reason. Finally, we check what we mean for exact performance of a contract, having regard especially with the situation of the performance of obligations, the distinction between obligations of results and obligation let's say best efforts obligations. Finally, we the class will deal with the so-called validity of the contract. The validity of the contract is when a contract is challenged and for some reasons, either because of lack of essential elements or because of lack of let's say of the legal capacity and stuff like that, it becomes either void or voidable. Finally, we take into consideration the termination of contract for supervening events such as the failure to perform, supervening impossibility, or excessive onerousness.
Okay, thank you. I know that you have already started to take these lessons. How do you think are received until now by people who come from different backgrounds? So they are mainly architects and engineers. How do you think they are dealing with this kind of topics that are mostly studied by lawyers, by professionals from another area?
Yes, the classes actually are designed for people without a legal background, and the reason, and that is the reason why we use slides which are quite detailed in class, and that are detailed also for the review of the topics that we deal with in class, so that also for individual studies they can be taken as a sort of handbook, let's say. On the other side, the way I deal with in class about these matters is to provide with, let's say, the students with the key principles. The focus is on the key ideas of contract law. I think that to some extent, setting aside a number of technicalities that for the approach of people who are not pursuing, let's say, a legal career may not be may not be of value, of a particular added value. On the contrary, if we focus on the key principles and let's say we figure out a sort of checklist of what we have to control in the professional life, because I mean engineers working in construction companies or in companies, broadly speaking, they will have to deal, because they usually take important managerial positions, with negotiation of contracts, the performance of contracts, and sometimes also problems dealing with default of contracts. Therefore, if they have at least the key principles under which they figure out what is a checklist in order to have an effective contract or a valid contract, or what are the key principles governing the performance of the contract, and between them the major distinctions between obligation of results, best efforts, and what we mean exactly, for instance, with issues like the default or situations affecting the validity of the contract. This can be a good background, as I say, probably not for seeking, not to be able to have to answer themselves, but at least to raise the right questions. That is the goal. I mean, the purpose is really to provide the background to engineers, or there are also architects in the class, to, let's say, to be able to identify the issue and to ask, mainly to lawyers, the right questions. Because otherwise, I mean, and also for the lawyers that will be working with them, it will be very important, because dealing with people who are familiar with the fact that there can be an issue in the implementation of the contract in terms of applicable law, in terms of damages to pay, in terms of let's say guarantees to be issued, and stuff like that. That is of paramount importance, because in the company life, in the business life, they will have, I mean, engineers and lawyers will have to work together. And if engineers realize that, I mean, all their contracts, especially, for instance, construction contracts in the private, but also in public, and in particular in public sector, they need, I mean, they are really very complex documentation, and the complex documentation needs to be, let's say, carefully negotiated, accurately drafted, and very skillfully, I would say, implemented. That's
so to recognize when there might be a problem, not let it fester, but tackle it as soon as possible. So be able to face a problem as soon as when it is still small, and not let it get larger.
And carefully avoid, for instance, ambiguities in the implementation, or let's say to have a postponement in the problems that can be really detrimental sometimes to the projects that they are dealing with.
Okay, thank you very much.
Thank you very much.
Very helpful.